And hello, welcome. Once again, Employment Law Show. Good to have you here, John Scholes and Lior Samfiru. Lots of stuff, as always, Lior, to get through today, including what your employer legally can't do. We're going to get to that here in just a bit. We'll get to some phone calls from our radio show, which runs across the country, has for many years. You want to email anytime, help@employmentlawyer.ca. All this information will come across the bottom of your screen throughout the show. And the phone number, of course, 1-855-821-5900. But we always start fresh, get warmed up, as you like to say, with the week that was. What do you got for us this week, pal?
Always the employment law. That's what I got. One day maybe we'll turn it around and kind of mess with everyone and talk about other things. But for now, and on this show today, we're going to talk like we always do about workplace rights. Probably one of the most important topics always, especially over the past year with COVID-19. There's been no one that I know where his job or her job hasn't been touched some way by this pandemic we've been all dealing with. So this is the place where I can tell you what to do if you're facing a workplace issue. Maybe it's COVID-19 related, or maybe it's not. Your laws are still here. Your laws have not been suspended. Your rights are still enforceable. So if you want to know what to do, if you have questions, usually, John, when people call me, the questions start with, Lior, can my boss do ... These are very common questions. We'll talk about a bunch of stuff like that today. But if you want to ask me your question, your specific question, we'll give you my phone number, we'll give you my email address, so we can have that discussion anywhere across Canada. There are no bad questions. There are no issues. And when I shut off the camera here and stop talking on this show, I go back to do what I do, which is to help real individuals with their workplace issues. So let me give you an example, talk about a situation that I dealt with very recently. I spoke with a lady who had worked for a dental office. She'd worked there for a long time, close to 12 years. Now, because of COVID-19, they were slower than usual. A lot of people may not have been comfortable going to see their dentist. They don't want to necessarily leave the house or go to that environment because they're afraid of the virus. So they were slower. And her employer said, well, we like you. You've been here a long time, but we're going to let you go. And here's your 8 weeks of pay. And in fact, I actually think they offered her 10 weeks. They thought they were being nice and generous. So it said, we're going to give you 8 weeks plus 2, so 10 weeks, and off you go. She knew, even without speaking to me or even seeing this show before, she knew that this didn't sound right, or she felt it didn't sound right. So she said, well, I've been there for 12 years. Are you saying that 8 or 10 weeks is all I get? Well, what her employer said, well, what you don't understand is we're a small business. And we don't pay the same as the big companies. We only have about 5 employees, so we don't have to pay any more than this, so that's all you're owed. She called me. At that point, she still wasn't satisfied with that answer, and she called me. So here's the real answer. Here's what the law says. Small company or not, big company, small employer, does not matter. The same severance obligations apply. After 12 years, and she's older, I assessed her as being owed about 14 months pay. That's months, not weeks. She was offered 10 weeks pay. And I wanted to bring this up because I see this all the time. Employers that mean well, okay? I'm not saying she had a bad employer, not at all. Employers that meanwhile get confused by the law. They assume that as a small business, there's different rights that an employee has, or there's different obligations for the employer. That is not true. That is not correct. Doesn't matter big or small. And when it comes to your full termination entitlements, you get the same. Remember the factors: age, position, and length of employment. For her, that's 14 months pay. Now, I'm not picking on her employer. I'm not saying that the employer should be penalized. All I'm saying is that's what she is owed. If you're in that situation, regardless of who you work for, or regardless of the type of business, or even the reasons why you've been let go, let's have a discussion. Let's make sure that you get everything that the law says you should have.
It's interesting because, over the years we've been doing this and the radio show for so many years. It's and again, not to pick on the medical profession, but these medical professionals, doctors, dentists, whatever the discipline is, they're working longer. I know so many doctors that are in their late 70s and 80s, and they have people working for them that have been there for 3.5 decades. And then they decide to either shut down the practice or pass it off to maybe a sibling who's become a doctor, wants to take over the office. They have a built-in, list of clients and patients. But they always, not to their detriment, they shortchange their employees, or they say, you know what, you're allowed to stay here because my daughter or son is taking over the practice, right? How does that affect their employment if that happens?
Well, the nice thing is for an employee is if your employment continues with the buyer, with the son, with the daughter, on the same terms, all that means is your seniority carries through, which is good.
Right.
You get to keep your job and keep your seniority, meaning if at some point down the road you are let go, you're going to get your full severance, which accounts for the time you were with the previous owner, previous employer. So that's a good situation to be in. Now, for those people that will lose their job because the doctor retires or because during the sale to someone else, they're not being hired, these individuals have significant severance entitlements. And as you've said, John, many people that have worked at doctors' offices have been there for decades. Yeah. Individuals like that could easily get 2 years severance. So if you're ever in that situation or your friend, relative is in that situation, hopefully you now know what to tell them. 2 years severance could be owed easily. So they have to give me a call to make sure they get it.
And that number, even though it's on the screen all the time, 1-855-821-5900, the website, employmentlawyer.ca. You can check that out at your leisure as well. While you're there, you can snoop around and find a radio station near you across the country that carries our long-running radio show. And from it, we play back some phone calls from our listeners that have questions, I'm sure, just like you do watching this program. So, Lior, we'll get to phone call number 1 right now.
I was off for 2 years sick. I went back to work, and they let me go a week after that. And I was there 18 years.
So as soon as I hear that, John, as soon as I hear someone is off on a medical leave for a long time, they come back and then shortly thereafter they're let go, it starts to raise red flags. Why is that person let go? Are they let go because of the fact that they took a disability leave, because of the fact that they were sick? Because if you are let go because you were sick, because you took a disability leave, that's illegal. That's a human rights violation. You cannot be let go because you had a disability. You cannot be let go because you're off work with a disability. And if your employer does that, right off the bat, that's a human rights violation. So the first thing I'd want to understand is, why was he let go? Maybe it's possible that the reason doesn't have to do anything with the disability. Maybe it's just a coincidence. I'm not a very big believer in coincidences. But if he was let go because of that human rights violation. Now, beyond if we put aside for the reason for termination for now, he still is owed severance either way. So after 18 years, that's going to be a substantial amount. But let's go to pocketemploymentlawyer.ca. Let's plug his information into that tool, our severance calculator tool at pocketemploymentlawyer.ca, and see what he's owed. So we know that he has been there for 18 years as a middle manager. Let's assume he's 49 years old, just for our exercise here today. You can see at the bottom of your screen there what he is actually owed: 18 to 24 months pay. 18 to 24 months pay. That's a significant amount of compensation that he's owed, easily into the 6 figures. So that's apart and above any human rights damages he may be owed. So that's the answer here. If you're ever let go because of your medical condition, in any situation when you're let go, without severance, old or young, doesn't matter, go to pocketemploymentlawyer.ca.
You know, this one's interesting too, because it was 2 years or just over 2 years till he was able to come back to work even though he was let go. What is the concept if someone is off work and they finally realize it could be 2 years or longer and they say, you know what, I'm never coming back? What does the employer do at that point?
So generally speaking, if an employer can show, number one, a lengthy absence, so usually 2 years or more, and no likelihood of coming back to work, that can result in what we call a frustration of contract. Meaning the employer may be able to say, you've been gone for so long, we can simply end the employment there, and any severance obligations at that point are going to be very minimal. But again, lengthy absence and no likelihood of coming back to work. In my experience, a lot of employers say frustration of contract when they haven't actually reached that point.
Terminationquestions.com, another great resource for you to ask questions for Lior. He or his team will answer them back. I want to get one today, Lior. First one from Darren. Again, terminationquestions.com. Darren says, my employer is going to bring in a 25% pay cut next month. She says it's the only way the company will be able to weather COVID-19 and that she has the legally right to do it. I haven't been told how long this will be for. 25%.
That's a big pay cut, John. 25% is a huge pay cut. And I want to be very clear on this. I cannot be more clear than what I'm about to be. Your employer does not have a right to reduce your pay in a significant way. Anytime we talk more than 15%. If they do, that's a constructive dismissal. That's true regardless of where you are here in the country. That's true whether or not that's because of COVID-19 or not. COVID-19 has not changed this. So for her facing a 25% pay reduction, she can treat that and should treat that as a constructive dismissal and say, no, I am not accepting that. You've essentially terminated my employment, and now I'm owed severance.
You know, it's interesting, too, because we always flip it around and saying if she went to her employer and said, you know, legally, I'm going to take another 25% increase in my pay. How does that sound?
Yeah, so employee shows up to work and say, you know, I've thought about it a lot over the weekend. I've decided that effective tomorrow, you're paying me 25% more. Thank you for your cooperation. Right. I mean, you're laughing here, and it is absurd. But from a legal standpoint, it's exactly the same as the employer saying, I've decided you're taking a 25% pay cut. It's not something an employee could do to say 25% more, and it's not something an employer can do to say 25% less. Either way, it's not allowed. Either way, an employee has rights that cannot be violated.
All right, coming up here, what your employer legally can't do. That is on the way, so stick around for it. In the meantime, help@employmentlawyer.ca to reach out through email. And I'll give you the phone number again, 1-855-821-5900. Employment Law Show, stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back. By the way, anytime you want some more advice, and we're not doing this show or the radio show, or Lior's busy, you can go to pocketemploymentlawyer.ca. It's like having a lawyer in your pocket at all times. There is contact information on that website as well. But let's get into this, Lior, what your employer is legally not allowed to do. Number one, we touched on it a little bit before the break, and that is reduce your pay or demote you as well, right?
John, most of the times employees, when they call me, as I said, start asking me the questions, or the question starts with, can my employer do this or that? So we want to talk about some of those things that I get asked very often, which really start with, can my employers do this, or is my employer allowed to do something? And these days, probably one of the main questions that I'm getting is, can my employer change terms of my employment? Can they reduce my pay, cut my pay? Can they demote me, give me less hours? So the answer almost always is no. Your employer does not have a right to make significant changes to the terms of your employment. If they do, that gives you, the employee, a right. And it gives you the right to treat that as a constructive dismissal. So if you're facing a significant change, you have two options. Option number one is you can accept it. Remember, of course, if you accept that change, that reduction, that demotion, you give the company the right to do it again. It's not a one-off thing. But that's option number one. Option number two is you can choose to treat that change, that demotion, that pay reduction, what have you. You can choose to treat it as a termination of your employment and say, that's it, I'm done because of what happened, and I'm going to make you and my employer pay me my full severance. Remember, of course, severance can be as much as 24 months' pay. So if you are facing that change, before you tell your employer, that's it, I'm out of here, before you even say the severance word to your employer, I want you to call me. We need to do this correctly. But no, your employer cannot just reduce your pay, demote you, reduce your hours. None of that is possible because it gives you the right to treat that as a constructive dismissal.
Okay, number two, another thing your employer can't do is make you retire or quit your job.
Yeah, well, you know, this is a key. We talked about this on a previous show and a number of shows. Is the only one that can decide if you retire, the only one that can decide if you resign, well, it's you. You're the only one that has the ability to make that decision. By definition, a retirement or a resignation is something that you do yourself voluntarily. You do yourself unilaterally. So your employer cannot tell you, I've decided you're retiring, or I've decided that you've resigned. Unless you told your employer, I have news, I'm retiring, I'm resigning. Unless you've done that, your employer cannot deem you or consider you to have retired or resigned. If they do that, really what that is a termination, meaning they have to pay you severance. In some situations, that could even be a human rights violation. Your employer says, well, because of your age, we're going to need you to retire next month. No, they cannot deem you to retire because of your age. And anytime age factors in, age discrimination is a human rights violation. So no, you cannot be told or being made to retire, to resign. Only you can decide that.
I think a lot of people are still under the misinformation that there's a mandatory retirement age, which there hasn't been for a long time, right?
No, there hasn't been, depending on your province, a good 15 years, even longer. There's been no mandatory retirement, and meaning your employer cannot tell you to retire 65, 75. You can work as long as you want, as long as you're able to do the job. And even if you can't necessarily do the job in the same way, your employer still has an obligation to accommodate you. So let's forget about this concept of mandatory retirement.
Number three, another thing your employer can't do is refuse to pay you overtime for work that you've already done, right?
So very important to remember that overtime has to be paid if the work is done, even if not approved. So if you had to work overtime because you had a deadline, you had a lot of work on your plate, I got to stay late and finish this, or I got to work late this week because I got to get my job done, otherwise boss is going to be upset, but you never got that approved. Now, you should always get it approved. You should always do things legitimately. But if, despite what I just said, you worked it, even if it wasn't approved, you still have to get paid for it. Your employer cannot say to you, well, I didn't tell you to work overtime, or I didn't approve it, so I'm not paying you. If you worked it and if it was legitimate, then your employer has to pay you for that overtime. Now, the fact that you didn't get it approved may become a disciplinary issue. Your employer may say, well, I'm going to provide you a warning, etc., but they still have to pay you for overtime if it was worked.
The next one here, Lior, on the list is probably the one that's become the biggest, been right to the top over the last year during COVID-19, and that is put you on a temporary layoff. It is rampant across the country.
It is that, absolutely. And it's shocking for many employees to, and by the way, John, I have employees that have heard me say this week after week for months, and they still don't necessarily understand it. Yeah. So I'm going to say it again, and hopefully this one will make it make sense. Your employer cannot put you on a temporary layoff, even if it's because of COVID-19. Now, of course, we're only talking about non-union employees, but your employer cannot and does not have a right to do that. Regardless of whether you're in Ontario or in BC or in Alberta, it does not matter. If you've been put on that temporary layoff because of COVID-19 or otherwise, you can choose to treat that as a constructive dismissal. You can choose to treat that as a termination. The reason you may want to do that is it gives you some certainty. It gives you payment now that you need so you can support your family and have time to find another job, as opposed to staying on a layoff for months and months, not knowing what's going to happen, trying to live and survive on government benefits. So for many people, that may be an attractive option. If you've been laid off temporarily, you can accept it if you want, or you can choose to treat that as a termination and get your severance, which you can do now. If you want to do that, give me a call and let's make it happen.
We are talking about things your employer legally can't do. And next one is this: create a toxic work environment, right?
So I'll go a step further. Not only, of course, is your employer not allowed to create a toxic work environment, they can't avoid fixing a toxic work environment. So if you're aware, or you make your employer aware of a poison work environment, a toxic work environment, your employer has to roll up its sleeves and get to work to fix that problem, to investigate and then make it go away. They cannot avoid it. They can't say, well, that's your problem, I'm too busy, oh, come on, boys will be boys. None of that makes sense. None of that is legal. Your employer has to create a healthy, positive work environment. And if the work environment is not that, your employer has to get to work to fix it. That's not just a moral obligation, that's a legal obligation. So if your employer does not do that, you know what to do. You reach out to me. Sometimes me gently and nicely reminding your employer of its obligations does the trick. Other times I can simply get you out of there so you don't have to deal with that. Whatever the issue or the concern, let's talk.
And finally, this last one, still a really big one. Why you get all the phone calls is they can't let you go paying you severance or termination or firing. They got to pay you. They have to give you your severance.
Unless you've done something terrible, you stole, you hit someone, you committed fraud, you refused to show up to work for no reason. Unless you've done something really, really bad, your employer, if they let you go, has to pay you severance. Now, your employer is allowed to let you go. I am not saying that your employer cannot let you go. They can, but they have to pay you your severance. Remembering, of course, as I've said, severance can be as much as 24 months' pay. Most people, over 90% of people, what they're offered is not that. It's a lot less than what they're actually owed. But you don't need to wonder. You don't need to be concerned. You can find out now, this very moment, what you're owed. Grab your smartphone, your tablet, your desktop, doesn't matter. Go to pocketemploymentlawyer.ca. Put in your information. By the way, by information, I'm talking about your age, years of employment, not your name. And you can find out in seconds how much you're owed.
We do this for 30 minutes every week, but if you want the hour-long radio show, employmentlawyer.ca is where you'll find a station near you that carries the show. And we'll get to phone call number 2, Lior, from our radio show right now.
Someone is fired for cause. First of all, what does cause mean? And second, if you are fired for cause, does that mean their obligations for severance are non-existent?
Good timing, because we were just touching on that. So cause means it's a termination because of something awful that you did. And because it's so bad, your employer can let you go without severance. But it has to actually be that bad. Maybe you've done something wrong, or even a few things wrong. That does not mean that it rises to the level of cause. Causes were used for the worst offenders, where whatever the employee did is so bad that it's not possible to continue employing them. In my experience, the vast majority of times when an employer says, we have cause, you did something wrong, it's not cause. In fact, it ends up being a wrongful dismissal. If the employer can establish cause, if your employer can establish that it's really, really bad what you did, then no, severance does not have to be paid. In all other situations and other circumstances, yes, your employer is going to have to pay you your full severance, even if they said it's cause, even if they try to terminate for cause. And by the way, I mentioned pocketemploymentlawyer.ca. One of the tools there allows you to find out if the company, in fact, did have cause to let you go. So check it out yourself. Find out at pocketemploymentlawyer.ca.
All right, I want to get to one more phone call from our radio show, Lior, but we got to take a quick break first, so we'll do that and then get right back to it. 1-855-821-5900, the number to reach out, and email anytime, help@employmentlawyer.ca as well. Coming right back.
People think you aren't owed severance pay if you are fired for a reason. Employmentlawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at employmentlawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. Employmentlawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Employmentlawyer.ca is the website. Catch a radio station near you that carries our long-running radio program. Call into it if you want and ask your questions there sometime in a future show. And from one of those shows, Lior, we're going to get to call number 3 right now.
I'm at a car dealership, and I run the service and parts department. And during the first wave of COVID, everyone in my department got laid off except for myself. So now for the second one, we've done it again. And I'm working 6 days a week, and haven't seen an increase in pay, and the business is not down that much.
So I think the key here is to make sure that your employer knows that you're not okay with it, that this is not something that you've accepted. If you simply want to be, the good soldier, I call this, and say, keep quiet, I'll continue working and do my best, you're going to be considered to have accepted this new reality where you do a lot more work and you do the work of other people without extra pay. That's not a good thing. So what you need to do, what he needs to do, is to send his employer an email. And I say email because I want it in writing, saying, I'm very concerned about what's happening. You've let people go, and I have to do their job. I need you to do something for me to help me out. I can't continue this way. And you give your employer a bit of time to fix that issue. If your employer doesn't, if they still say, well, too bad, it's our right, we're the boss, you still have the right then to treat that as a constructive dismissal. You don't have to accept this. You don't have to continue working in that situation because your employer has not done what it's supposed to do, which is to keep your job the way that it's supposed to be. So put it in writing, make sure your employer knows you're not comfortable with it. That protects you and allows you to say constructive dismissal.
All right, Lior, I want to bounce over to terminationquestions.com for one of lots of questions you get on that website. You can have one as well. Sign one in, or at least give one to Lior anytime. His firm and a member of the team will get to it. This one you're going to love comes from Mateo. He says, I was working as a realtor for a large real estate company for 7 years when COVID-19 hit, and I was placed on layoff. I expected to be recalled when the housing market picked up again, but was told that I wouldn't be returning and that they can make the decision because I'm actually a contractor. Is that true? When did the housing market slow down?
Housing market slowed down. I guess it depends where you are, but not in most places. But the real question here is really the comment that this person made at the end of their question. Well, the employer, the real estate company said they can let me go and not pay me anything because I'm an independent contractor. Now, this is a touchy subject for people in the real estate business because there's a huge misclassification that's actually going on. Most of these real estate agents that are treated as independent contractors, truly in the eyes of the law, are employees. Why? Because they work for one brokerage house. They do what they're supposed to. They get their leads from that brokerage house. They have to follow their policies. They do this full time. They have a regular job, so they are employees. Very, very common in the real estate industry. Most people, real estate agents, are in fact misclassified. Now, that's important for many reasons, and it's especially important if you lost your job. Because if you are really, in the eyes of the law, an employee, then you're owed severance as an employee. Same with this person. They lost their job for whatever reason. I'm not even going to get into the reason because the employer is allowed to let them go. But just because they're a real estate agent and been misclassified, like so many others, as a contractor, doesn't mean that they are. They are likely an employee, likely owed severance. So if you are a real estate agent, remember what I said. I know it's a touchy subject for your employer, but you're probably an employee. So the next step, the next question is, how much severance is this person actually owed? Well, let's go to pocketemploymentlawyer.ca right now. Let's plug that information. Let's find out now in seconds, very quickly, how much severance is this person owed. So we know that they're a real estate agent, been there for 7 years. I don't know, let's pick 53 years old. It's a nice age. And they didn't get any severance because the real estate agency says, no, you're an independent contractor. They're not. They're an employee. And as you see at the bottom of the screen, they're owed about 8 months' pay. 8 months' pay, depending on their income. That's certainly going to be tens of thousands of dollars, potentially even more than that. So real estate agent or anyone else, if you're quote unquote an independent contractor, chances are, many people are, misclassified, meaning you are owed your full severance if you lost your job.
Lots of information right there, Lior. And again, are you an independent contractor? Are you not? There's a good way for you to find out very quickly, even before making that phone call. Pocketemploymentlawyer.ca. There's a section on there. Not surprised. You can check that anytime. It's anonymous. It's absolutely free. And I'll give you some contact as we're rolling out of here. 1-855-821-5900 and help@employmentlawyer.ca. Check us out and follow our radio show as well. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.